All right, everybody. Well, welcome. My name is Chad Harmon. I am one of the partners here at A&I Financial Services, and we're excited to bring Ms. Stef Deters, one of our favorite attorneys that we work with, to the table today to talk about an area of your financial plans we think just might be the most important at the end of the day. And so a couple housekeeping items before we kick things off. You'll notice everyone on the call currently has their video off and is on mute. We will be recording our presentation to share on our website. So for protection of your privacy and ours, we want to make sure we keep our video off until the end when we go into Q&A. If you do have questions that pop up during the presentation today, please use the chat box, which you'll find at the very bottom of your screen. Towards the middle, there's almost like an instant message feature where you can type in questions. We'll use that to control the Q&A. Our goal is to get you in and out today in a little less than an hour. So we'll leave about 15 or 20 minutes for questions at the end. And as always, all of the advisors on the call will be willing to hang out as long as we need to afterwards and make sure everybody's got their questions answered. So we'll go ahead and kick things off here. For those of you new to A&I Financial, we are a small boutique family practice who's now been proudly serving the community for over 35 years. Our goal is to help our clients both grow and protect their investments and gain more choice and control over their taxes. And the second part of that deals with issues like estate planning. And that's why we bring professionals like Stef here today. I'm gonna brag on her for a minute or two before I hand things over. Stef is a longtime member of the community here, originally started her schooling out at University of Wyoming and then finished up here at DU. So we've got a proud DU tradition both at our firm, and Stef helps continue that for us. She is the principal and managing partner of Deters Law LLC, who specializes in working with folks just like you, getting your estate in order and making sure we've got all our T's crossed and then dotted all our I's, and we make a transition as easy as it can be when that time comes. Before joining Deters Law, Stef was an attorney over at another law firm we worked with, Goodspeed and Merrill. And prior to that, she was with Holm, Roberts, and Owens working as in their private client service group. I'm going to go ahead and hand things over to Stef. Again, if you have questions, please use the chat feature, and we will be able to address those before we wrap things up today. So Stef, thank you so much for joining us.
Chad, welcome everyone. Gosh, I need to have this recording play every morning when I wake up, because it's so nice to hear great things when someone else is speaking great things about you. So thank you, Chad. We're going to go ahead and get started. I consider this presentation kind of estate planning 102. For those of you that have an estate plan already in place, there might be some information here that will be helpful for you to discuss with your existing estate planning attorney. And also with your A&I advisor, particularly with respect to some tax planning that might need to be, that might be coming up. And we're going to talk a little bit about that shortly. And then for those of you who might not have an existing estate plan, this information will be helpful in identifying how to get started. So I'm going to go ahead and share my screen here. Let's see. Okay, can everybody see that? Chad, can you see that?
It looks like it's coming through.
Slides here. My contact information is here, and I think if any of you have any follow-up questions after this presentation, you're more than welcome to reach out to me over email or over phone. Quick disclosure, like we all have disclosures, especially lawyers. I'm not your client, or you're not my client. I'm not your attorney until you're officially engaged. So everything that I'm providing here is just informational. I'm not going to be providing any legal advice. This is really intended to just inform you about what you can do as part of your estate plan if you have an existing plan, or if you're looking to set up an estate plan, give you some guidance on some things to think about. So what is in your estate? I've listed a couple of things here. Houses, this can include your primary residence. It can include a second home or a vacation home. It can include homes that you have as investment properties. It can also include things like timeshares. A lot of people don't realize that timeshares are typically held by deed. And so when you do your estate plan, it's very important that you share all of your real estate ownership with your estate planning attorney so that they can properly advise you on how to title those assets as part of your plan. Another thing to think about on the real estate side is oil and gas, if you have oil and gas rights, and also water rights. Those are sometimes held by deed as well. Vehicles. This can include your primary vehicles that you drive around town every day. It can also include things like collectible vehicles, perhaps ones that you've inherited or holding in the family that you don't drive as often. It can include boats and campers as well. Investment and banking accounts. This is both not what we call non-qualified and qualified accounts. Investment accounts that you might have at ANI or at other institutions. Bank accounts would include checking accounts, savings accounts. CDs is another one that oftentimes when we're doing estate planning, clients forget that they have that little CD over at a banking institution. So it's important to include all of your assets when you're thinking about your estate planning. Business interests, if you hold, if you're a shareholder in a C Corp or an S Corp, or if you are a member in an LLC or an LLP, a partner in an LLP, those are all considered part of your estate. Retirement accounts, 401ks, 401(b)s, 403(b)s, IRAs are all retirement accounts, and we're going to talk a little bit about some of the recent tax changes as it relates to those retirement assets that transfer to your intended beneficiaries at death in a little bit. Life insurance is also included as part of your estate. So if you have life insurance, the proceeds of those policies can become part of your estate when you pass away. And personal property. Personal property is tangible items, things that you can touch. I often think of this as things in your home, collectibles, jewelry. It can also include things such as ATVs and other assets that might be titled but are tangible. You can touch them. We're going to talk about this in a little bit, but personal property is one of the largest areas of concern when you pass away. And so identifying those personal property items that you have is very important as part of your plan. And then anticipated inheritance. So if you think you might be a beneficiary of someone else's estate, those assets could become part of your estate when that individual passes away. What does an estate plan do? An estate plan allows you to decide who receives your estate when you die and how they receive it. It protects your inheritance from creditors and what I call financial predators, which we'll talk about in a little bit as well. If you have minor children, it allows you to nominate who you'd like to serve as the guardian of your minor children. Guardianship is who raises your children, not necessarily the person in charge of the inheritance, but rather who decides how your children will be raised, what schools they go to, what their curfew is, what foods they eat, what doctors they see, what churches they might attend. Designation of who you want to be in charge of administering your estate both during life and death. Oftentimes we think about estate planning as only what happens when we die. Actually, there's a lot of documents that estate planning attorneys prepare to help protect your assets if you become incapacitated or you experience some level of dementia or Alzheimer's. An estate plan can also minimize estate taxes as well as income taxes upon your passing. It can reduce court costs by the avoidance of probate. We'll talk about that in a second as well. And also minimize unnecessary legal fees if the plan is done properly. An estate plan can give instructions for your care if you become incapacitated. This is sometimes referred to as guardianship, who makes decisions about your person, about what food you eat, what medical care you might receive. And it gives you the power to make your end-of-life decisions. Do you want to receive a life-sustaining procedure at the end of life if you're terminal or if you're in a persistent vegetative state? It also will give you the power to decide if you want to receive life-sustaining procedures such as food, hydration, and food. Okay, what happens if you don't have an estate plan? Well, I often say, if you don't have an estate plan, the state of Colorado will do it for you. The statute will govern who will be entitled to receive the assets in your estate, and it will also determine who can be in charge of administering your estate. If you become incapacitated and you don't have planning documents in place, the court can appoint itself or someone else as your conservator and your guardian, which might not be the same person that you would want to serve in that capacity. So having a proper plan in place can avoid the court intervening in those types of decisions. If you have minor children and you don't have an estate plan, oftentimes the court will control the funds and determine who might be fit to be a guardian of your minor children. And that person, again, might not be the person that you would want to raise your children. A judge is not going to know anything about your family or your wishes, and so having this information in place will help avoid the court making these decisions for your children. Okay, one of the first questions we often ask clients is, what type of estate plan do you want? Do you want a will or do you want a trust? And when I refer to trust here, I'm talking about a revocable trust. Revocable trust is something that you can modify, change, amend, terminate during your lifetime, as opposed to something called an irrevocable trust. Irrevocable trusts are not as common in basic foundational planning. Irrevocable trusts are typically created for maximum asset protection or for tax planning. So when you speak with an attorney about doing an estate plan, you want to make sure that you're talking about a revocable trust or a will-based plan. If you decide that you want a will-based plan, there are a couple of advantages, and I've listed them here. If you don't anticipate owning any real property in another state, either by purchase or receipt of real property by inheritance, a will might be a good plan for you. Typically, we recommend a revocable trust if you have real property ownership in more than one state. And the reason we recommend that is to avoid the probate process that is triggered upon death if you hold real property in your individual name. So that would, if you have property in more than one state, you have you could potentially trigger probate in both the state of Colorado as well as the state where the other piece of real property is located, and that can be very expensive. So avoiding probate in both states, if you have property, again, in more than one state, we would oftentimes recommend a revocable trust versus a will-based plan. If you value privacy and do not want the world to see who you've named in your plan and what assets you own at death, a trust might be a better option for you. With a trust, again, you avoid the probate process. Probate is the court process that we go to transfer assets out of your name and into your intended beneficiaries' names. With a trust, there's no probate that is triggered, therefore there's no public record of what your estate plan looks like. If you're not too concerned about privacy after you pass away, then a will might be a better choice for you. If you're looking for just a simple plan that it doesn't cost a lot to create or maintain, oftentimes a will-based plan is a better way to go. Trusts are not always as expensive to prepare, but if you have a lot of assets that need to be transferred into the trust, there can be additional costs associated with that. So if you're looking for more of a simple plan, a will might be a better solution. If you want to protect your assets and give your family a little bit more flexibility if you become disabled, I typically recommend a trust plan. It's a little bit easier to administer a trust during incapacity than it is for assets that stay in your individual name. If you want to avoid the cost of probate at death, I generally recommend a trust. Probate in Colorado is actually quite easy and it's fairly inexpensive. The legal fees to go through the court process are only a few $100s. But you typically, your personal representative or executor would typically have to engage an attorney to help them through that process, which can add to the expense of administration. Generally speaking, an estate that is administered through the probate system in Colorado takes about a year on average to fully administer. Oftentimes it takes 1 to 3 years. So there is a little bit of a timing issue there that can be concerning for some individuals. Attorney's fees range depending on the complexity of the estate that's going through probate, but generally speaking, I would say it's about $3,000 to $5,000 to go through that process with an attorney. If your biggest concern is you want your children to be taken care of when you pass away, really either a trust or a will is a good solution for you. Both plans can maximize some protection and some planning for children or other beneficiaries. Okay, estate taxes. Will my family have to pay taxes when I die? This is an interesting area because it is currently, could be changing in the next few weeks. Estate taxes are different from, in addition to the probate expenses and final income taxes. So when you pass away, if you've had taxable income in the year that you died, there will be an income tax return that will have to be filed. But you may or may not have an estate tax that is due upon death. Estate taxes the rate of estate tax is 40%. And that tax has to be paid generally within 9 months of death, and the IRS only accepts cash. They will not accept a child as compensation for taxes. They will not accept real property or any other assets. They really want that cash. Who pays estate tax? Well, right now, the only people that are subject to estate tax are those who have an estate that exceeds $11.7 million. If you're married, that's a combined amount of $23.4 million. And so if you have an estate under this amount under the current law, you're likely not going to trigger that estate tax when you die. However, there has been a lot of talk over the past year about a change to this area. In the initial proposal by the Biden administration, there was an indication that they were going to keep this exemption as it is, but they were going to do something called elimination of step-up and basis. Step-up and basis is the difference between what, or basis is the difference between what you purchase an asset for, and when you die, what its value is, fair market value. And as of right now, when you die, all of your assets, with limited exceptions, get something called a step-up and basis, meaning that if you have a home that is worth $1 million when you die, but you purchased it for $100,000, there would be $900,000 of taxable gain there. But if you die with that asset in your estate, then your children take, or your beneficiaries take the value as of date of death. They do not have to pay any capital gains taxes on that $900,000 of gain that you have in your home. That is still currently the law, but that was up and on the table as something that the Biden-Harris administration had proposed to eliminate, meaning that your beneficiaries would have to pay that, presumably pay that capital gains tax at death. That seems to have been taken off the table 2 weeks ago. The Ways and Means Committee came out about 2 weeks ago and indicated under the Build Back Better proposal that's currently being considered, there was nothing about a change in the capital gains, that step up in basis proposal, but rather what they have indicated is that they would like to reduce the exemption amount from 11.7 million down to roughly 5.8 million per person. So what that means to all of you is that if the Build Back Better plan passes, then instead of having 11.7 million that's protected from estate tax at death, that amount would now be roughly 5.8 million. Now, again, if you are under that 5.8 million, you might not have to worry about this, but if you're at or above that 5.8 million, you may want to consult with an estate planning attorney, consult with your A&I advisor about some planning that you would want to do before the end of this year. The proposal that came out 2 weeks ago from the committee indicated that that exemption amount would decrease effective December 31st, 2021. So there are some planning techniques that we can put in place to maximize the available exemption before it goes down. In addition to the proposals out of the Ways and Means Committee, there were some income tax increases for people who have higher earnings. There was also a proposal for an increase in the capital gains tax. I'm not going to talk about that in detail here, but I would recommend that you reach out to your A&I advisor and talk to them about those potential changes that could be coming down the pipeline before the end of this year. There may need to be some planning done on your side before those go into effect. All that being said, 2 days ago, I think two or 3 days ago, there was some indication from the House that they are not going to look at passing this Build Back Better initiative. And so if that is the case, if that is going to be tabled, then these potential tax changes are not going to go into effect. So again, just watch all of that very carefully and keep an eye on the news. Talk with your A&I advisor about any potential changes you might want to make before year end if it does pass. 5 things you and your spouse, parents, loved ones need to discuss now. What assets do you have and where are they? This is really important. Like I mentioned at the beginning, identifying your assets and making a list of those assets is very important. What kinds of assets are they? Do they have benefits that will transfer to your beneficiaries or loved ones at death? Do they go automatically to a spouse, or do they go to children, or do they not have any beneficiary designations listed and as a result will go through the estate? You want to identify how your assets are currently titled. If you're married, are they in both of your names? There are 2 different ways that married couples often hold assets. It's either in jointly with right of survivorship, meaning that upon the death of the first spouse, the asset automatically transfers to the surviving spouse without need for probate. Or sometimes assets can be held as tenants in common. Tenancy in common is each spouse owns 1/2 of an asset. And if that is how you hold a certain asset as tenants in common, husband and wife, that could trigger probate upon the first spouse to die. So those are important things to know about how your assets are titled. It's important to look at those payable on death or beneficiary designations. Again, talk with your A&I advisor about, maybe the assets that you have under management with them. They are going to know what those designations are and identify, is your spouse listed, your children, your other beneficiaries, or is it blank? And if you don't have a beneficiary designation on a particular asset, especially if it's a retirement account, it can have adverse income tax consequences to your beneficiaries. So you want to make sure that as part of your plan, you're identifying what these assets are and how they're currently titled. And then what tangible personal property do you have? Go through your house, look through, sometimes I recommend you just go room by room, make a list of things that you think are important to your beneficiaries, not necessarily a value per se, like a financial value, but rather, do they have sentimental value to any of your children or your other beneficiaries, grandchildren? These can be, again, vehicles, heirlooms, photographs, jewelry, collections, firearms, tools. Do you have life insurance? Consider what would happen if your spouse died or what would happen if you died. Oftentimes, if there is a primary spouse who's bringing in most of the income, we don't always think about the spouse that might be at home or working part-time as being an important piece of your big plan. And if something were to happen to the spouse that might be bringing in something happens to the spouse that might be part-time or facilitating with rearing your children, if something happened to them, the surviving spouse is going to need some funds to help with the care of the children and taking time off of work. And so life insurance can be a great immediate access to cash to help cover those expenses. Term life insurance is usually not that expensive, so that might be something that you, again, talk with your A&I advisor about, your estate planning attorney about, your insurance provider about, to see if that is something that you might want to add to your current plan. How would you make that mortgage payment? How would the kids be taken care of? Are important factors to consider. And if there's both spouses, it's important to consider if life insurance might be a good addition to your existing portfolio. Where are all your important legal documents? If you have deeds to your home, deeds to your vehicles, if you have an existing estate plan, is your will in a home safe, or is it in a safety deposit box at the bank? Who has a code, a key, or an access to the safe? It can be really stressful for family members to not be able to access the safe when you pass away unexpectedly and having to call somebody to drill into a safe. Make sure that you give somebody that you trust information about where this, how to access that safe. You don't have to give them the code. You can make it very complicated for them, so that it's, you have a little bit more security. You can say, look under the stairs on this one particular board, you're going to find the code, and you can make it safe without making it impossible for them to access the safe. So I always encourage everyone to make sure at least one person that you trust has access to this information. As an example, I had a client a couple weeks ago. We were able to find a copy of his mother's will, but we couldn't find the original, and the family tore apart the house. They looked everywhere. The attorney who had drafted it is deceased, so we didn't have anyone to call at the attorney's office to find out where they might have recommended the original will be placed. And as a result, we had to open probate in a different way. We weren't able to use the copy of the will. So an original will is necessary if probate's required. And so it is important for somebody to know where all of your important documents are located. Have you taken steps to avoid fighting between loved ones? Make sure you fill out something called a personal property memorandum if you already have an existing estate plan in place. A personal property memorandum is a document that you can complete to designate personal items, tangible items, to go to specific individuals. By doing this, you're going to reduce the amount of fighting and disagreements amongst family members as it relates to those sentimental items. A majority of the clients that come to me after a parent passes away or another loved one passes away are a result of not having clarity on who was supposed to get what inside the house. And those sentimental items are really what drives family members apart and results in a lot of legal fees to administer the estate. So having a really good, solid, completed personal property memorandum is very important. Ask your children what they want. Ask your grandchildren what they want. You don't have to give them what they want, but it is nice to know what might be important to them for purposes of filling out that personal property memorandum. And again, we're not talking about assets, investments, bank accounts, houses. We're talking about tangible items, things you can touch, things in your home. As an example, personally, when my father passed away, he had a completed personal property memorandum, but my brother had some items that were in my dad's shop that he really wanted. He had never told my dad. He had learned to use those tools when he was a kid, and they had sentimental attached. He was sentimentally attached to these items, and he would have really wanted them. And so that's a good example of why talking to your children can be important. Consider making gifts of personal property now. If you're ready to kind of part with those items now, it can help again in eliminating some of the disputes that can occur when you pass away. Label specific items. Tangible personal items in your home are not titled assets typically, so labeling them, putting a little sticky underneath them or identifying them. I've had clients who've done that, and it seems to work pretty well to know which items go to which family members. Giving some information to your family or writing it down about your funeral and burial wishes. Do you want a funeral? Do you want a burial service, a celebration of life? Do you want to be cremated? Do you have a prepaid burial plot or funeral services? I'm a big proponent in prepaid burial plots funeral services because it eliminates or takes one more stressful event off of the family's plate when you pass away. If possible, put your wishes in writing so that there's no confusion or disagreements among the family members as to what your wishes were. Again, when you pass away, it's a very stressful time period, and having all of this in writing is really going to help the family members get through the grieving process. Okay, how to save time and money by creating an estate plan. Kind of just my general rule of thumb, you only get one chance to do your estate planning, and if you screw it up, you'll never know, but your family will. So make sure you have a really good, solid estate plan in place. Try to avoid online or do-it-yourself forms. I oftentimes say they're fatal, and the reason they're fatal is that those forms that you get online or at OfficeMax don't contemplate all of the different planning techniques that an attorney can help you with, and there's some complexity involved in those documents that you might not fully understand what the outcome will be, and it can oftentimes result in disputes amongst the family. In addition to that, a lot of those online forms don't follow the necessary protocols for being a valid will or valid trust in the state of Colorado. So even though you may fill out one of those forms, when it comes to me after you pass away and the family's asking me to review it and file it with the court, the court, we usually in many cases can't file it as a valid will. And as a result, we either have to go through formal probate proceedings to utilize the non-compliant form, or we have to just assume that you don't have a will at all. So either way, it's usually not going to work out in your favor or in your family's favor. Holographic wills are permitted in Colorado. A holographic will is a will that you write yourself. However, again, I usually don't recommend that because they're heavily contested and often, again, do not accomplish your intent, particularly if there are missing important pieces in that holographic will. A good estate plan will include the following documents. So when you go to look for an attorney to help you through this process, you'll want to find someone who can prepare all of these documents for you: a revocable trust and or last will and testament, financial power of attorney, medical power of attorney, living will, personal property memorandum, instructions for funding your revocable trust or changing beneficiary designations, special power of attorney and guardianship appointment if you have minor children. Some additional documents you might be looking for is something called a declaration of disposition of last remains. That's your burial instructions, can be an additional document. When I do an estate plan for a client, I also include a brief summary of all of the documents so that you have kind of a 2-page document you can look at every few years, make sure that it still is consistent with your wishes versus trying to pour through, several hundred pages of documents to identify what your plan was at the time it was signed. So these are the main documents that you should be looking for as part of a good foundational plan. Let's see. Hire an attorney who specializes in estate planning. So estate planning professionals are more intimately aware of alternative planning methods that can save you money. In some limited cases, an attorney might recommend that you, given the types of assets that you have, might indicate that a simple will is an appropriate plan for you versus a revocable trust. Or based on your assets, they might, and your intent and your goals, they might say, no, a revocable trust is a good option. In addition to that, if you have other situations that might need additional planning, an estate planning professional is going to know that. If you want to fund education for your children or grandchildren, they're going to be able to help guide you on that, as well as work with your A&I advisor on things such as 529 plans. If they're going to be able to identify if you need additional asset protection as a result of the type of asset you might hold. For example, if you have investment properties, real estate specifically, you have a greater level of risk as a result of having real estate investment properties. And having a good estate planning attorney can help you identify ways to minimize some of that risk associated with owning investment properties. Estate planning professionals are typically aware of proper planning techniques to reduce income and estate taxes at death. So there are a lot of things that we can do to reduce income taxes to your beneficiaries. We can also help you reduce estate taxes again if you exceed whatever the exemption might be at death. Like I said, currently it may be before the end of the year, it may be reduced to roughly 5.8 million. So those are things that estate planning professionals can help you with. While all attorneys are all licensed attorneys can prepare estate planning documents, I usually recommend you find somebody who's really focused in this area. Having the litigator next door might not always know about what to do your plan, might not know what some of these alternative planning methods might be, or might not identify some planning that can be done to reduce some of those income and estate taxes. Go to your first meeting with your attorney prepared. Know kind of what you want before you meet with your attorney. If you have children, identify, do you want to leave assets to your children equally? Do you want to have you made some advanced gifts to some of your children, and do you want those offset at death? This will save your you and your attorney some time, as well as typically some money. Know who you want to serve as your fiduciaries and guardians. Who do you want to raise your children is one of the most, if you have minor children, is one of the most difficult questions for parents. But really talk about it with your spouse before you go into that meeting. So you're not trying to make a quick decision or maybe make the wrong decision because you feel pressure to make the decision while you're with your attorney. So think about those things before you go into your meeting. My rule of thumb for all clients is no one is going to be the parent that you are. Try to find the second best, okay? When it comes to nomination of guardianship. Consider who you want to serve as your medical power of attorney, your financial power of attorney, and your executor. Those are all fiduciaries, and try to identify the people that you trust to make those decisions for you. Complete your family financial album with your A&I team. This is the most amazing document that I think I've probably ever seen out there in terms of helping you really take all of your information, take your assets, and put it in one place. A completed family financial album will save your family a lot of time, a lot of energy, and reduce their stress if you were to pass away. So work with your team to complete that financial album. If you do that album in advance of meeting with your attorney, it's also going to help your attorney identify those assets and help you decide which plan is best for you, a will-based plan or a revocable-based plan, or do you need some additional planning done outside of those two primary foundational documents. The album will also help you outline your assets, your liabilities, who you have named on certain POD accounts and beneficiary designations in advance of completing your plan. All of those are important pieces to kind of have in place before you have that first meeting with your estate planning attorney. And then once your plan is in place, hopefully, or while you're putting your plan in place, there are what I consider three main important trusted advisors as part of your team who can really help you create that robust and complete estate plan. Your A&I team or your A&I advisor, your estate planning attorney, and your accountant or CPA are all part of your team, and having them all on the same page will really help you both during life, towards the end of life, if you become incapacitated, and also help your family with the transition of assets and the administration of your estate or your trust at death. And this is going to ease stress on the family members significantly if you have a full, complete plan and they know they have these three individuals to go to help them in that process. And then I was going to just spend a few minutes talking about some examples of clients that I have worked with A&I team members over the years, and then we can take some questions. My first example is a client where that went through a pretty major life change. This client had a death of a child, and which is something that we never, as parents, hope that will happen, but sometimes it does. And as a result, there was a significant change in their estate plan. Their INA advisor and I met with the client, sat down, really thought through the changes that were going to be made, the individuals that now needed to be updated in their plan as a result of this stuff, identifying who a good executor or personal representative would be, identifying the contingent beneficiaries of the plan, and getting those things in place to just ease some of the stress of the family member. And we did that all together. At the same time, we also looked through the beneficiary designations on all of the client's accounts and made sure that those were all updated, so that should something happen to the client, their plan was thought through as a result of this major life change, this death of a child. The second example I'm going to give is an administration of estate where there were multiple beneficiaries, and including minor grandchildren. And in this case, the individual had an estate plan that was completed by another attorney, and A&I did a great job of making sure that all of their assets, all the assets under management at A&I had proper beneficiary designations consistent with the plan that was put in place by the estate planning attorney. Unfortunately, in this case, the client likely did not tell their attorney who prepared the plan that they had timeshares. And so as a result, it did trigger probate to move those timeshares to the proper beneficiaries. However, one of the more complex issues as a result of this administration was there were some minor grandchildren, and minor grandchildren, of course, cannot hold assets in their own name. And there were some complexities as a result of that, but we, both myself and their advisor, in this case, who was Chad, we worked together to maximize some of the income tax planning for this particular client, and making sure that the grandchildren's shares were all taken care of. And Chad worked with the grandchildren to set up accounts for the receipt of the assets. And although it was, it was a more robust, it was a larger estate, he really helped those grandchildren set up those accounts, helped the trustee get all the assets distributed in a way that was income tax efficient. And then my last example is one that I handled a few years ago with Cameron. If any of you are familiar with Cameron at A&I. In this particular case, the trustee who the decedent had nominated as part of their trust plan declined to serve. And as a result, we had to very quickly identify a successor trustee to manage this trust for the child beneficiary. And Cameron went above and beyond to try to identify a good corporate fiduciary who was willing to accept this trust and manage the assets and work with the child beneficiary to receive distributions and come up with a good plan for that beneficiary. So between the two of us, we were really able to work together and find the right solution in a situation where we didn't anticipate a corporate fiduciary resigning. So those are three great examples of times just recently that I've been able to work with A&I on maximizing some of that estate planning and administration after somebody passes away, and easing some of the stress on both the clients and the family members. So that is all I had to talk about today. And I think we're just right on time for some Q&A. So Chad, do you want to start?
Yeah, thank you so much, Stephanie. I think it's obvious to everybody on the call why our trust in you is so high, and appreciate you being such an incredible resource for us. Everybody on the call, you are on mute. Please feel free to unmute yourself if you do have a question. I have one in the chat log. We'll go ahead and tackle first. This question is related to somebody who is originally living in Colorado and has now moved out of state to Texas, and is asking what specific recommendations should we consider in updating our current plan? What's the most important items and areas that we need to focus on?
So Texas is a community property state. I don't know if this individual is married or not, but community property states are a little bit different from common law states like Colorado. So if you have a Colorado plan in place, you may want to meet with an estate planning attorney who's licensed in Texas to take a look at how your plan may change as a result of those community property laws. If you have a trust in place, there might just need to be some updates to some of your what I call ancillary documents, medical powers of attorney, financial powers of attorney, living will. Those documents are very state specific. If you have a trust, that's one of the benefits of having a trust in place is we call it the suitcase benefit. If you move out of state and all of your assets are already titled in that trust, you don't necessarily need to do this complete full revamp of your estate plan. You can use your existing trust with some minor change of law edits, and then you'd have to update some of those ancillary documents. But for the most part, if you have a trust in place, it's a nice vehicle for moving from state to state. If you have a will-based plan, you probably do need to consider consulting with a Texas licensed attorney to identify what those documents and those statutes are that govern those particular ancillary documents, so that if anything happens to you, it's much easier to administer your estate.
That's great. Thank you, Stephanie. Any other questions? You can feel free to either type those in the chat box, like I said, or just speak up, take yourself off mute. You can find the mute button in the very bottom left corner of your Zoom screen for those of you that are new to Zoom, but I think at this point, we've all probably had at least a little experience using it. All right, we'll give it a minute or two here. While we're waiting for some questions to pop up, I will make a comment. Stephanie did a great job addressing the recent tax proposal that was presented to the House floor, and if that passes, that'll move on to the Senate and then the president for signature. Couple areas that may be affecting our clients here, on top of the issues that Stephanie mentioned, which were the reduction of the exemption for the estate tax, possible income tax increases, as well as capital gains increases, a backdoor Roth IRA conversion. Those are going to be going away if this bill were to pass. That is where we put after-tax money into a traditional IRA and then move that over to a Roth IRA for individuals who have higher incomes who are not eligible to contribute to a Roth. Also, for higher income earners, Roth conversions in general may be going away, and they're looking at phasing those out over the next 10-year period. So if that is part of your plan or something that you've looked at in the past, please talk to your advisor here at A&I, as these are urgent issues that we do need to address, some of which would require action sooner than later. And if you're looking for additional information on that, Carl, our president, put together a fantastic piece that went out in our Periscope, which is the weekly newsletter we send out to all of our clients. It is detailing this from the top down, and really, I think, was a nice comprehensive summary in a way that's easy for all of us to understand what they're talking about. So please check that out in your email. It's also available on our website. All right. Any other questions anybody has? Don't be shy. Stephanie, you have solved the estate planning issue. We have figured it all out. Well, if we don't have any questions, we'll go ahead and wrap up for today. Again, we do put on these educational events for our clients as a value add for you. They range in topic from things directly related to your investment portfolio to areas like estate planning or wealth transfer. Our next event is scheduled for October 13th. The topic is going to be college funding strategies and hacks. So we are going to show you how to put all your kids and grandkids through college with absolutely no expense. So don't miss it. I say that facetiously, but these are going to be some great tools for everybody on the call on how to properly help these kids get the education that they deserve. I think we may have had one more message pop up here. Let me see if I can pull that. It's just some very kind words rather than a question. So thank you, everybody, for being on the call. Stephanie, do you have anything you'd like to close with?
No, I think I hope this was really helpful for everyone. And again, if you have any questions for me, feel free to reach out to your A&I advisor and they can connect the two of us. I'm happy to answer questions offline if you're more comfortable doing that. I'm here to be a resource. So, but thank you, Chad, for putting this on. I think hopefully this is a good end to the year, and we'll see what taxes turn out like. Crossing our fingers, they're not going to change a whole lot. But if you don't have an estate plan in place, now's a great time to get it put in place. Potentially, especially if you have
Yeah, absolutely. And, for those of you who don't have your estate plan in place or haven't checked it for a while, I think just having a heart-to-heart with yourself and thinking about what if tomorrow comes and I'm not around, how is my spouse going to be affected? What impact would this have on my kids and my family as they're trying to both grieve the loss of you and deal with the estate settlement? It can be a daunting task for anybody. So tools like our family financial album, which we're really, really proud of. If you do not have one, talk to your advisor. We will get one out to you. I think it's one of the most valuable tools we provide for our clients. And getting your estate in order, I honestly feel can be one of the largest stress reducers available to you. So if you have questions or concerns, please talk to us. We will connect you with our great trusted resource like Stephanie and Deters Law. They've done a fantastic job taking care of us and our clientele for many, many years now. So with that, we'll go ahead and wrap up. We appreciate everybody joining us today. I'm sure we all were able to take something of value away from the call. Stephanie, you're wonderful. Appreciate your time, being as gracious as you were, offering up your time for everybody on the call. So thank you very much. Have a great day. And please join us on the 13th for our next event.